Hi, my name is Phyllis, and I will be acting as a juror in case number 3. Public hospital corrects impermissible disclosure of patient health information in response to a subpoena. In this particular case, the plaintiff, a former patient named Jennifer's information was released by the defendant, AU Hospital, after receiving a subpoena that was not accompanied by a court order. So a little bit of history about HIPAA. HIPAA was signed into law August 21st, 1996 by President Clinton. The purpose of HIPAA was to improve efficiency and effectiveness of the healthcare system by providing electronic records, more security for patient health information, and less chance of patient health information being abused or stolen in paper form. In most cases, HIPAA prevents healthcare providers from disclosing a patient's personal health information without a valid authorization from that patient. There are instances in which a covered entity may use or disclose the patient's health information without written authorization from the patient or without the opportunity to agree or object to the authorization or the release. The newly coded version of the privacy rule indicates that there's an explicit exception to disclosure of patient health information during judicial proceedings. So that brings us to question, was this case a judicial proceeding? Well, we know that there is a subpoena involved, but we also know that it wasn't court ordered. So it was likely issued by a court clerk or an attorney and not an actual judge. So I wouldn't necessarily call this a judicial proceeding. They're not actually in court. It hasn't gone to court, whatever this issue is. So they're just gathering information. So I don't think this would qualify under the judicial proceedings rule. So that brings us to question, what is the hospital's responsibility for notifying Jennifer? Did they fail to give her satisfactory notification that this information was being sought after? Did they fail to allow her time to seek a protection order to protect her personal information? According to the Health and Human Services government page, a HIPAA-covered healthcare provider or health plan may share protected health information if there's a court order involved. So then we look at the defendant, AU Hospital. So they are allowed to disclose personal health information in the event that there's a court order involved. However, they have to prove that they offered or provided reasonable notification of the request to the patient, and they also have to, if they cannot prove that they gave reasonable notification, they must then seek a qualified protective order for the information from the court. So there are rules. You can't just say, oh, I got a subpoena, I'm just going to release this information and see what happens. There are steps that have to be taken to ensure that the information's released properly, that the information is it's the right information that's being given out, and that type of thing. So there has to be a lot of focus on that. A covered entity must make reasonable effort to limit the personal health information to the minimum necessary to use, disclose, or request. So what this means is you can't just tell them everything. If they're asking for labs, that's all you give them. If they're asking for an encounter note, that's all you give them. You don't give them the entire patient's record, because that is giving way too much information. We want to go for the minimum necessary to get the information from point A to point B and nothing more. We don't want to elaborate. We don't want to give, anything other than what is specifically required. There are a total of 6 possible disclosure exceptions set forth in the privacy rule. One of these is the required by law exception. So what this looks at is the state law versus the federal HIPAA law. So if the state law is more stringent as far as protecting the privacy of a person's health information, then the court will default to the state law. However, if the state law is less stringent, then the court will default to HIPAA as far as protection of privacy. So in this particular case, we don't have a whole lot of information to go off of, other than the information was released by the hospital and that Jennifer didn't realize that her information was being released. So I think it's pretty clear that the hospital failed to protect Jennifer's personal health information. They also failed to follow through with the rules that are put in place to protect patients' health information. They did not give her reasonable time to act once they received the request, and they did not request a protective order for her information or even give her the chance to request that. So in this particular case, I believe that the hospital is at fault and that they failed to follow the HIPAA law. So I would side on the plaintiff's side in this particular case.